Hello, I'm Professor Boardway with MBA Educational Horizons and MBA Architectural. I represent both companies. And in this recording, I want to talk a little bit about architectural theory versus reality. And I know when we went to school, the college and universities and such, they taught us mostly theory instead of the 1,000 different ways that architects practice. It's pretty much the only common way that's relative to everyone in school is the theoretical approach. You know, one project, one client, no budget, no schedule. I mean, the professor gave you the program criteria, but then, which is like mainly from the client. And then a time frame, which is a deadline. Okay, so that was kind of realistic there. But, when I went to school, we didn't have computers, so, we just did ink on vellum and then wrapped it around foam core boards or whatever. I mean, my senior project, I think I had like 20 or 30 boards, and of course we don't do that today, we're mostly on computers, but pretty much the same logic carried over, who programmed the computers, and but mostly it was theoretical, and so you presented to the class and the professor and so on, and then you got critiqued on what to do and that type of thing. So it's a matter of going through and realizing that. But I know that some in the past, the history has been that some professors had a problem with that because you could have a student with a bachelor's or master's degree and coming out of college and not have a clue about how the real world works because they've been trained on theoretical, So that's why it's always nice while you're going to school if you can somehow part-time work for an architectural firm or a professional firm and get the realistic experience that way. So then that way you got kind of the best of the different types of the approaches, theoretical and reality, and you go from there. There's a lot of things that school doesn't prepare you for. Challenging clients, giving you unrealistic, budget schedules and level of quality and things of that sort, and expecting you to do things for them, and you have to realize the difference between what is proper practicing and what isn't. Okay, architects do not make owners' decisions or agency decisions. We are not the representative of the owner. We are a consultant of the owner. I don't have the power of the owner. They need to reflect that authority and power, and basically, or hire a representative that can represent the owner. We call it the legal representative of the owner. So that if I can't find the owner and an owner decision needs to be made now, then I've got a backup person, the legal representative of the owner, not an attorney, but someone that can legally represent them. Okay. And so we have to ask, the owner who that's going to be. It can't be the architect and the construction manager and the general contractor and somebody that already is wearing a hat, so to speak, or has a role as a party in the project. Can't be doing a dual role, because then you have somebody with two different hats going on, conflict of interest, and it just doesn't work. So it has to be a separate person altogether. But going back to theory versus reality, I mean, in my seminars, some of my candidates or the students will basically say, well, Professor Boardway, it doesn't work that way. The way it has to work is, and so on and so on. And I know that, half of what I say in my seminar, I realize that it's theoretical because I'm preparing them for their exam, as opposed to reality, And so when a question comes up in the exam, you have to answer it, the theoretical ideal way of answering, as opposed to, well, this is the way that I would do it, You never pass the exam with that type of approach, And so they're not testing you on the way you would do it. They're testing you on, do you have knowledge of the theoretical way the architect should do it? That's kind of what's being tested, you know. And so we have to kind of turn our thinking around when I'm preparing candidates for the architectural registration exam across the U.S. or the California Supplemental exam or the NCIDQ, and because I do tutoring and teleseminars and all of that as well. And so it's a matter of, the individual, the test taker, realizing that there's a difference between theory and reality, okay, as well. And so, if a client gives you an unrealistic budget and schedule, we have to bring it back from theory down to reality, and wants to do a school for $300 a square foot or whatever. It's like, well, no, it's got to go on up, and then the school has to drop down and the budget has to come up so it balances out, it works, and it's realistic. And sometimes we have to bring theoretical things back into reality, in the real world. And so there's not one way of properly practicing architecture. There's usually a number of different ways suited best for your firm. I mean, if you just do tenant improvement projects and that's it, or shell buildings, and that's going to be a different type of contract than one that does 20-story hotels or whatever. I mean, one of the stories is that when AIA contracts were written, American Institute of Architect contracts were written, it was like one contract for most projects or all projects. That's the reason why some of the erroneous or ambiguous terms are still in there, like the architect shall visit the site at appropriate intervals. It's like, well, what does that mean, And the attorneys back in D.C. who writes AIA contracts, I'm on the phone with them sometimes, and I'll ask them, well, what do you mean by that? And they'll say, well, every project has different appropriate intervals, so we can't specify, which is true, because every project, is it a fast-track, complicated project? You're out there once a week, or just a standard, 2-story office building, whatever, it's like once a month, So it just depends on how, what you feel is properly practiced architecture for this project, as well as following the practice acts of your boards or states. Check with them as well, making sure that you're doing everything legal and above board and, ethical and, that type of thing as well. And then write that into the contract. I mean, when in doubt, don't leave it out, spell it out, That way the owner knows exactly what's expected of you. And so you're all on the same page, or same wavelength, and they're not expecting something else totally different, And so that's something that we're always, making sure the client is understanding. I mean, we'll send them progress sets of documents at 20, 40, 60, 80%, getting them to sign off, mark it up, send it back to me, confirming the fact that I've kept the client up to date progressively. So that's important to do. And making sure that they understand what they're signing off on as well. Okay, that's important to do, as well. Because sometimes they'll just finally, it's like, okay, go ahead, and approve something, and they don't know what, and then they come to the party during construction, and here comes the, the comments that should have occurred, a year ago or, 6 months ago, It's like, I didn't think the space was going to look like this, and so on. Now, did you do the due diligence to confirm the fact that they understood their end product, as well? And I mean, it's kind of presumptuous of us to sit down and open a set of drawings or whatever and expect them to read the documents to our level of understanding. So it's a matter of making sure they're understanding what they're looking at, what they're paying you for, what they're paying, the contractor for to build the building and so on. And so, there's no surprises. I mean, when you drop a ball, you don't follow through. I mean, that's inviting surprises, and we don't want those. We're done with surprises. I call it silly stuff after a while. So what I do is I prevent the silly stuff from happening by trying to get out ahead of it as well. Let's talk about it now, even though we're not going to get to it for another couple of months. I want to make sure that everyone knows the ground rules of, when a revision occurs or a clarification. I mean, there's only two effects to the project. It's either going to be a revision affecting time and/or cost in the form of an add or a deduct, or a clarification supplementing the data you've already, generated, not affecting time and/or costs in any way. And so, is it a clarification or a revision? They have different terms for them. Usually I just call it clarifications and revisions up to bidding, and then we call it addenda, or that's both, and then after bidding, then it goes into change orders or clarifications, But anyway, so there's different terms based on whatever phase you're in. Yeah, but again, there's theoretical and there's reality, and you're going to ask yourself, should I do it this way, or should I do it the way the client wants me to do it? And then, because I know that if I do it the way the client wants me to do it, they're going to give me more projects. But then, how much value have you sacrificed in yourself, as well as jeopardizing possibility of liability, as well? And so I know that, I'm here to say that if you stick to your guns and do it the way that you should be doing it, 9 times out of 10, the owner's going to come around. They have to. They can't ask you to do something illegal. I don't want an estimation. I want an accurate cost analysis, and I'm an estimator, as an architect. I'll get you within 10-15% of construction costs. I recommend that you hire a professional cost analyst if you want a more accurate number, and I probably just saved myself a lawsuit, So understanding the boundaries of where you need to go in practicing architecture, that's important. And don't step outside those boundaries, because if you do, then you're exposed for liability, and you don't want to go there either. I mean, I've been practicing theory for a long time, and I pretty much stay out of trouble, for the most part. But I'd love to go into the job site and, hey, talk with the subs and let's, how you doing? Any questions? Yeah, but I've done that before, and they twist whatever I said around, and well, that's what the architect told us to do, and that wouldn't have occurred if I didn't go over there, and so much for being a nice guy. When you stop being a nice person and you don't trust anybody, usually is the time you stay out of trouble. Of course, you don't have a lot of friends, but anyway. So, but it's a matter of properly practicing architecture, having a good standard of care. All right, and making sure that you're following the Practice Act of your state, as well. Take a look at that if they have one. And talk to your boards and your disciplinary departments there as well. Okay, should I do this? Should I not do this? You can always get advice, or they can recommend the attorneys that represent them, and maybe you get 5 minutes of free consultation. That's some of the ways that I've got my legal knowledge, and I'm an expert witness on law cases as well. So we have to kind of watch out for some of the words we used as well, and because there's energy in words, right? It's like, so it's a matter of making sure that we indicate what your services are, what your responsibility is, and your level of proficiency as well. That's important, and making sure that you're properly practicing architecture the way you should. And if you have any questions, just give me a call. This is what I do across the United States. I prepare the candidates for the architectural registration exam and tutoring and teleseminars, and as well as the California Supplemental exam, and I also do NCIDQ. And then once they're through with the exam, I also do 10 professional subjects. So we call it professional in training. Everything's on computers right now, and so we do Facebook or FaceTime rather, and Skype or GoToMeeting or Zoom, or one of those formats as well. And so sometimes they'll put me on a 70-inch screen, and in the firm 15 people will attend, and and then I go through and we talk about the subject that they want to talk about, as well. All right. But if you have any questions, you can give me a call, and we'll talk to you on the next recording. All right. Take care. Bye bye.